Hello guys and welcome back to Pamoja Trust podcast, where we share information that is beneficial to communities but also respond to our everyday lives. Today we are here with my colleagues. They'll introduce myself, but my name is Sally and I'm your host for today.
Thank you. My name is Tobias. I'm an urban planner and urban designer, and I work here at Pamoja Trust.
My name is Tobias. Yes, Jack.
My name is Veronica Koech. I work for Pamoja Trust under the Federation and Movement Building Program.
So today we will talk about what to do when you receive an eviction threat, and try and understand what is even an eviction, and is there lawful eviction, is there unlawful eviction, how should communities organize themselves when it comes to eviction, something that Chep here, as we call her, has a lot of expertise on, mobilization and federation building, and what are other steps that communities can prepare or get ready when they receive eviction threats. And to start this discussion, I think it's good for us to maybe understand what is an eviction. Tobias.
Okay, thank you, host. An eviction is an issue which is becoming more common currently, especially in our urban areas. Eviction is simply the removal of an individual or a group of people or a community from a piece of land where they have been residing for a certain period of time. It may also be a removal of an individual from a housing infrastructure where he or she has been staying for some time. Mm-hmm. So simply, in the simplest time, that is what eviction is.
Okay. So when people say illegal eviction, unlawful eviction, informal eviction, Chep, maybe you help us understand from your many years of practice, what is it, what constitutes informal, what should be like a formal or a lawful eviction?
Thank you, host. From where I sit and through practice within Pamoja Trust, we perceive, normally we receive cases and the community comes to us because either they've been issued with a formal eviction notice, or sometimes it's verbally, where when it's verbal, an eviction may be issued through the area chief. It may be issued through a politician, an area politician, or an opinion leader, verbally. At times, communities, during their meetings or during their day-to-day engagement, the leader or someone carrying the eviction message comes to them and tells them there's a planned or the proposed eviction to be undertaken. It's an informal notice, so hence it carries an informal message. And for formal notice is where an institution, an organization, or even an individual has issued a written notice to the communities, giving them, notifying them of a planned or a proposed eviction.
Okay.
Yes, and for Pamoja Trust, when the communities comes to us, we ask them two questions. First of all, we ask them who is planning to evict the community or even an individual, and then the community either whether they are aware or they are not aware. Sometimes they tell us the notice was issued through the chief or the politician. And then we move further to probe whether they are aware of who is planning to evict them. And if the community is aware of who is planning to evict them, we send them back now to go and inquire or get more information on why there is a planned eviction. And if they are not aware, again we ask them to engage the bearer of the message. And in terms of the form of engagement that we are asking them to get is they now need to do the formal inquiry through writing.
Okay. I think the reason why what CHEP is the reason why what CHEP is saying is important is because it's some sort of advocacy strategy to kind of get information, and it's important because for evictions to be lawful, there is an element of fair administration. There has to be fair hearing, there has to be information that is shared, there has to be written notice. So all this kind of constitute to what a lawful eviction should be. So I think from practice, what we've seen is that communities come to us in instances where there have been a lawful eviction, or maybe the threat itself already is a red flag. The eviction might be unlawful. And so to kind of try and find ways of meaningful engagement, there are things that we might need answers on, right? We need to know who is the bearer of the eviction, as CHEP puts it. Is the notice, first of all, lawful in terms of Tobias? I think the law itself kind of gives us guidelines on what constitutes lawful eviction in terms of the duration, right? In terms of how the notice itself should be communicated to the community. So just for the benefit of the communities to know, what are those guidelines so that when they receive that threat, even before they think of coming to Pamoja or calling CHEP, what are the things that they should know at the back of their heads in terms of what the law says?
Okay, thank you, host. Maybe to elaborate from where you have left, for lawful evictions, there must be lawful notices which are given according to the legal regulations that exist in the land. So the notice that is given must be first in written form. So if it is in an oral notice, then it becomes unlawful eviction process. So for the lawful eviction process, the notice must be in written form, and this notice must be served to the person who should be evicted, or the person, the community who is residing where eviction is supposed to take place. This notice must also indicate the reason for the eviction. Why are they evicted? And this notice must also give room for the communities or the people who are going to be evicted to communicate their ideas or their proposals on how they think the eviction process should be carried out. In terms of timeline, the law provides that eviction notices should be given at least 3 months prior the date of eviction, so that the residents of the area or the person to be evicted can also prepare and can also give proposals on how they think is the best way for them to be evicted. So legally, if the notice is a written notice, the notice is served to the community. That is that land, it should be within that land that is going to be evicted. It can also be served in the local administration offices, whether a sub-chief office or a chief's office or a sub-county commissioner's office. And this notice must indicate very well the piece of land. It must indicate very well the purpose of eviction. It must indicate very well the channels of engagement. If the communities want to engage with the agency or the individual who wants to evict them, those ones must be indicated in the notice.
So I think what we're agreeing here is that eviction is allowed if it's done within the law, right?
Yes, yes.
And the institutions or the authorities who are evicting have to then adhere by what the guidelines or what the law provides.
Yes.
But I think we've also, we know, tunaishi, like the world we stay in right now, sometimes authorities follow the law, sometimes they follow the law. And there is what we see on the ground that could be different from what is in our laws. And I think, CHEP, you've seen that a lot when it comes to the different scenarios of evictions or the different ways evictions have happened, for example, in our country. I think just to mention before you come in, CHEP, is that we've seen a lot of oral notices, right? A lot of oral notices issued to communities. And even the people who give these oral notices, most times it's the chief of the village area or just someone who's popular in some of the settlements where evictions are that where evictions mostly happen. Before we come to the different scenarios that we see in different communities, Chep, maybe someone would be asking themselves, why should I be evicted from my own land that I own? Like I have absolute rights. It's a private land. I own it. I have the papers. Why should I be evicted? Is eviction allowed in such scenarios? Any of you can maybe enlighten us on that. And what about if I don't own the land? Do I have the rights to actually claim for my rights and to demand that I should not be evicted from a land where I absolutely have no... Yes, I could have rights now that we understand what land rights are, but I do not have ownership rights to the land. How do you look at both scenarios? Private and where you do not have ownership to those to the land.
Thank you, host. I think thank you for pointing out the two scenarios, not really scenarios, but at least the two cases where an individual owns have rights to the land, and the other one without rights. Of course, with rights, but with no ownership. Possibly documents. I think in the first case of ownership, yes, you have rights, and somebody somewhere just rises up and they see eviction as the best way of depriving an individual these rights. And these cases happens mostly in the informal settlements. Particularly where people like women have access to land, especially the use of land. But then in some cases, some families or even individuals conspires and even decides they want to throw away these women or this lady. So that again, that's one scenario where an individual have access to use this land. But again, even in cases where developments are happening, and even developments in terms of infrastructure, in cases where governments or individuals have purposed to develop this land for purposes of even the communities to benefit. So in some cases, you realize that along the process, with the systems that have been laid and even the processes that have been laid, you realize people are prone to eviction because they do not own. Actually, the systems does not favor them. Number two is where, yes, you own this land. Not really, you have a right to access to this land and even own this land. But again, probably because of the developments that are going to be put there, at times, whoever is meant to be settled there, sometimes because of the conditions and all that, you realize that people are to be forced to be evicted forcibly, for some people to come in. And we look at this in some cases where some of the government interventions have being undertaken, like the other day I was reading a document where there's a proposed market that is meant to be constructed, a high-end market where there's already been traders who have been operating informally. So when you look at that, it tells you, of course, when the market is constructed, of course, with the kind of infrastructure that is going to be put, the costs are meant to, it will
exceed.
Yeah, it will lead to lead to people being evicted. I will cite a case of a railway station. So a railway station is meant to be put where informal traders are operating. So that again, you may not have the informal traders operating within a railway station. So what happens is that they are being evicted, and they were actually evicted. But to take us back is, I think also some of these notices also comes to, as opportunities for advocacy engagement for community. Like now, this case is where the traders now got an opportunity even to negotiate and ask the questions that my colleague Tobias was asking. For what purpose is this land going to be used for? And then what is our benefit? So that gives an opportunity for advocacy, for more engagement actually. And in the
I think I can come in there, and I think you're right when you say it's important to ask what the land is going to be used for, and I think this is key even as we dissect on the different scenarios of eviction on a private land and an eviction on a public land, like a land that the occupiers do not own. And I think as I don't know if Tobias mentioned it earlier, but I think the law provides that for private land, if government is coming in to do development, whatever development it is, they have to prove that that land is going to be used for public good, for public benefit, right? So I think that's kind of the threshold that the government has to prove to the community, and that's why it's important in the notice for them to outlay that this is the function, this is the use that we are going to use this land for, and that could be the construction of a road, construction of a railway, construction of affordable housing, for the benefit of like the entire public. So when it comes to private land, it's clear that you have absolute rights, you have title to and ownership to that land, but the state can come in to acquire that land, and they will not disregard the fact that you have rights to that land. They have to respect your rights, acquisition, and they have to ensure that you're treated in a dignified way, rights that are enshrined in our constitution. And so that's why our laws also gives guidelines or procedures when it comes to compulsory acquisition. So when it comes to private land, what then comes in place? Compulsory acquisition. It's clear in our laws how compulsory acquisition is done, how compensation should be done, and that's how actually the state recognizes that you have rights to this land by giving, first of all, demonstrating that the acquisition for that land is for public good, and thereafter also giving you adequate compensation to that land, right? And we have seen when it comes to monetary, sometimes 3 times the value of the land, depending on what the valuation report would say. And we have also seen sometimes it depends on resettling or giving an equivalent of when it comes to compulsory acquisition. So that's very clear, and most times people do not have, unless someone does not have information on what should be done, but most times the conflicts are usually on the compensation was not adequate. The compensation has taken a lot of time. Where we really see, and Chef is trying to also just give us a clear picture of what happens. It's messy. Sometimes there's no direct line to advocacy when it comes to eviction, where we have occupiers in good faith as the Constitution says. And for the benefit of someone who does not know occupiers in good faith, Tobias, maybe you can also expound on who is an occupier in good faith. And if I am me, Sally, I am occupying a land that for sure I know I do not have rights to, what should I do? Should I just say I do not own this land, check, I pack my bags, I go? Or what should I do? In terms of what should I do, but also in terms of what are my rights as well.
Okay, I think maybe to go back on the possibility of being evicted when you're on a private land, yes, it is true. according to the laws of Kenya, if the government or the government has a national strategic interest on the land, then they are able to compulsorily acquire it and use it. It might be for economic benefit, it might be for historical benefit, it might be for security issues. So if you own a land, then the government can take it and use it for the public interest. But what I want to stress on is that in that eviction process, there must be meaningful consultation and participation, which means that you must be consulted, you must be asked what your views are and how you feel you should be compensated. And that is why there are also several ways of compensation. It might be cash transfer, it might be an alternative location where you reside on. There are also people who occupy public land in good faith, which means they are aware that this land does not belong to them legally, but they are occupying that land for purposes of housing and also...
Before you continue, so that because people have always faulted civil society for advocating for people who do not own land, I think that's something we've heard of as people who've worked in the civil society before you continue, Tobias. And I just wanted to bring it out clearly that occupiers in good faith is actually something that is in our constitution, right? And the essence of it is that when we talk about land rights, we are not only talking about the title, which is also key, but we're talking about we usually say in our sector that when we talk about land rights, we have a spectrum, the bundles of rights. We have the right to use, we have the right to access. And those are the rights that mostly are accessible to women, right? We have many other rights, even the sectional property rights, where you own a section of a property, not the entire land rights, as we may put it. So when you talk about occupiers in good faith, it's not something that is birthed out of civil society advocacy, but it's something that is enshrined in our constitution, which is our mother law.
Thank you. I just wanted to say that you also have a right to occupy that land because you are entitled to a healthy and safe environment. You are entitled to access housing. And therefore, when you are staying in that land, you have some other rights in addition to the right to own that land. So when it comes to eviction, these other rights must also be considered because you have been living there. Maybe your whole life has been circulating in that area. So when you are being evicted, you are also entitled to some form of compensation, some form of meaningful consultation and engagement, so that when you are removed from that place, you are not thrown to the garbage.
And that's what and that's what occupiers in good faith or people who do not have title usually claim, right?
Yes.
I think also maybe to come in, I think there's been confusion when it comes to, these rights. And even with the provision within the Constitution, also rights have obligations. Yes, I may have right to access to this land, but also what am I doing for my part as an occupant also towards realizing this right. So I think that is where the problem comes in, and I think that is where CSOs are branded like we are advocating for.
There's something you say, Jeff, that has brought an idea on my mind. We usually say, and it comes to planning and also management of land, full use and something. There's a term that I think it's even a provision in the Constitution that land has to be used fully and sustainably.
Yes.
So if you left, land was left, there are people who came, settled there, they have raised their families there, they've lived there for many years. They are kind of using the land sustainably. So you can't just come and evict them and disregard the rights that you're mentioning, but also disregard the fact that these guys have been using the land that have been idle for some time.
Yeah, so I was saying, yes, we also have obligations as the occupants of this land. So and I think this is what gives us a leeway as Pamoja Trust also, even as we advise communities and as we support them even to engage in terms of realizing their rights. This brings an opportunity now to begin discussions or even negotiate. Yes, we understand this land, yes, we are occupying it in good faith. But again, we are able to justify and say we are occupying this, and now it's giving benefits both to the economics of the country and even as an individual. So with these evictions, as Pamoja Trust, we see opportunities now to engage for engagement. Yes.
Okay, so when it comes to, because evictions, we have seen, in short, we've seen evictions happen a lot, right? We understand what eviction is. We understand that there's lawful and unlawful eviction. We understand that there should be a notice. It should be put in a place where the community can see. I mean, it should be known by the community that there is an eviction that is coming for it to be lawful, and the consideration of other rights that should be looked at, as you have said. You have said that, for example, it comes to issues of compensation, there's a way that you can look at it, right? And it's clear that when it comes to private land, the land, our laws, especially the Land Act, gives us a clear guideline on how that should happen. But now, when it comes to occupiers in good faith, yes, we know they have these rights, right? And the other rights that comes to land rights. But we have seen a lot of struggle when they fight for their rights. We have seen a lot of court cases that kind of try to look at the issues of what should we do, or how should we look at compensation when it comes to people who do not really have title to this land. So just to share, maybe Chef or yourself, what are some of the things or struggles that you've seen communities have when it comes to struggling to say really what their rights are?
I think one thing that I have observed in most of the communities is that they don't have evidence that shows that they belong to that community. They have been staying there for this number of years. They have been doing 1, 2, 3 things on that land. So like when now it comes to compensation, it becomes difficult to identify who to compensate and who not to compensate. That has been a challenge.
So what would you advise communities to do?
We as Pamoja Trust, we have been advising the communities that they need to leverage on citizen-generated data that has been that is continuously being accepted in government agencies as authentic data, so that they can generate their own data and have the data of the investments that they have in this piece of land, the kind of families living in this piece of land, how many people are living here, so that when a case of eviction arises, they are able as a community to champion for their rights. And they know very well their numbers. They know what they want, they know what they have invested in that piece of land. Because in most cases you realize that when most informal settlements are evicted, then most individuals lose everything that they have worked for many years. So my perspective is that the most important thing for these communities is to ensure that they have their data that can be used as a reference point when it comes to eviction.
I think we'll come to how that fits into the resettlement action plan, and the reason why I'm bringing in the issue of resettlement action plan is because it's important to say that our laws, there has been a lacuna when it comes to that aspect. And I think courts have also pronounced themselves on that matter, that if you look internally at our laws, we do not really have a guideline on how to deal with occupiers, or how to even assess compensation occupiers in good faith. But that mentioned, our constitution also recognizes that, specifically in Article 2, that any other international instruments that Kenya has signed then automatically becomes part of our laws. And we know we are part of instruments like United Nations Covenant on Socio-Economic and Cultural Rights, etc. And some of those instruments clearly outlay how eviction should be done, what should be done when it comes to occupiers in good faith. I think that's where the issues of resettlement action plan comes up. The issue of community-led generated data, as you mentioned, which is very important evidences for community. And I think this we have also seen in recent cases, how important that data can be in helping the courts kind of try and assess compensation. So, Chef, maybe just shortly, what do you think the data, how does it feed into the resettlement action plan, and what is a resettlement action plan?
Thank you, host. I think even before I talk about the resettlement plan, I think the most important and what the challenge that we've seen with communities is lack of organization.
Yes.
Even for this data, community-led information and data to be generated, there must be some level of organization. And we've seen most of the communities that have been faced with the evictions, and eventually evictions are undertaken maybe forcibly, is because community do not have a voice. And one of the key things that we've been doing as Pamoja Trust is to ensure that the communities are organized. And once they are organized, they are able to know, first of all, identify the problem. Why are we being evicted? And is there a way that we can approach this the institution or even organization? So with that level of organization, even for a relocation action plan to be generated, the communities must speak in unison. Because a relocation action plan is a negotiated proposal. And so when it's a negotiated proposal, first of all, the two parties must come together, must agree and say, yes, there is maybe intervention in this land. So how best can we approach this issue? And that is when the relocation action plan comes in. Because the relocation action plan bears, first of all, it bears the information, the data, and then secondly, it bears a problem. What is this problem? And then the last thing is how can we deal with this this problem? So for a relocation action plan, even for it to be owned by the two parties, it must be, the communities must play a key role. And within even the relocation action plan, that is where we come in with now the parameters of compensation.
Okay, so what you're trying to say, and CHEP is a big community mobilizer. I think you have a lot of expertise on that, and what you're telling communities is that the first thing that communities have to do is to make sure they are well organized, right? And if they're well organized, then they're able to collect data, and do an enumeration, as we call it, and collect data as to who are the people who are occupying that space, in terms of how many households are there, right? And how many people are in a household, right? And in terms of structures and maybe property, what are the properties, the kind of structures that are there? Because we have in mind that they do not actually own the land itself, but they have rights to access, they have rights to use, they have rights to the investment that they've made there. So this is what the courts or any other institutions would use to maybe kind of have meaningful engagement with them. And we have seen this in practice, and these are, let's call them community innovation or even civil society innovations that have come to place to fill in that lacuna. And of course, we have also been championing for some of these practices to be adopted into law, so that at least we have a law that then guides authorities to deal with occupiers in good faith. Because on the other side, the occupiers in good faith have the right to these rights. But on the other side, we also have right to development, yes? And we cannot refuse development in the name of of rights, right? So there has to be a balance, and we have to have like a negotiated space. And I think that's what, as Pamoja Trust, as an organization, we always speak to communities, that there is right to development, and we also have other rights, and we have to kind of have meaningful engagement and a dialogue and an exchange with the duty bearers. And I think that's why Jeff also mentioned that when communities come to us, the first question is, who is the bearer of the eviction? Not to just know, but to also have in mind that we need to engage them, right? We need to also ask ourselves, is the development that is coming the right development? Do people need that road there? Could there be an alternative road? And I think some of the challenges that we can mention, we have seen them arise in courts. I think it's important to notice that when it comes to eviction, we can't go without mentioning the Mitubel case. That is a landmark case when it comes to occupiers in good faith, and also the recent case when it comes to the deep sea settlement, a judgment that was given just last year. And I think they lay very important principles that the world can use when it comes to evictions. I think one thing that is clear is that like the Mitubel case clearly stated that occupiers in good faith have rights, and it doesn't matter that they do not have title to that land. You have to, and thereby the eviction, the lawful eviction guidelines that we've talked about, and you also have to look at other rights. And I know from the Mitubel case, the big question was then how do we deal with assessment of compensation? Though it's also important for communities to know that why data is important is that cases like the Mitubel have used enumeration reports before to give them some sort of guidance into how to go about issues of compensation. But we know that issues of compensation still remains a key issue. I think in the and yes, as you
thank you, host. I think also there is another important case that normally it's not people have not explored it. There's a case by which was filed by some PAPs when a relocation action plan was being implemented. And then the Kenya Railways planned for an eviction. And in this case, Kenya Human Rights Commission, National Human Rights Commission was tasked with an responsibility to oversee the evictions within the Kenya Railways. And one of the conditions that was put is that for an eviction to be undertaken, actually there were like 6 conditions. One of the key conditions was that an eviction should not be undertaken without a forum, a stakeholder forum, for them to lay down the procedures of undertaking this eviction. Number 2 is that the PAPs must be engaged. The project affected persons must be engaged just to know when this eviction is to be undertaken in a forum. Another condition was that they should not be evicted during festive. Yeah. Either during festive seasons. Yes. In December, actually it was very specific to Easter and Christmas, December. The other thing is that when the rains are not, during rainy seasons.
The rainy season is important because the deep sea case also says something on it. They were evicted during a rainy season, and that's an inhumane eviction by itself.
Yeah, right? And it anonymously gave the National Human Rights Commission to oversee all evictions in the country. Actually, that is what the case seeks. So I think also this should also be a precedent kind of that we can refer. And if you look at what the CSOs, the civil society, have been pushing for, is that some of these guidelines be considered. Yes,
because they provide some sort of solution to a problem that we've always had. I wanted to read just a paragraph from the deep sea judgment, and I think this is important because they tried to, walijaribu to go back to what also Mitubel welfare case looked at. And by the way, the mutual welfare case, for the people who do not know, I think we cannot discuss it here, but it's a case that is available online. You can go and check more on it, what it was about. But the Supreme Court in the case of Mutual Welfare Society, now this is the deep sea judgment referring back to the Mutual Welfare Society, said, the Supreme Court in the case of Mutual Welfare Society versus Attorney General settled with finality the question of whether a person who is not an owner of a property deserves procedural safeguards. And those are the safeguards that you're mentioning in the case of an eviction. So the apex court, which is the Supreme Court, said that the country has yet to develop legislation and guidelines for evictions for persons occupying land for which they are not legally entitled to occupy. However, as a member of the international community and a signatory to the various UN treaties, like we mentioned, we are bound by such international guidelines as exist that are intended to safeguard the rights of persons liable to eviction. Article 2, 5, and 6 of the Constitution make general rules of international law, and any treaty or convention that Kenya has ratified part of the laws of Kenya consequently becomes part of our laws. So I think this is like a statement that is clear, and we are already seeing a lot of courts referring back to it. But also in this judgment, I think the judge goes back to say that key elements of lawful evictions under the guidelines include appropriate notice. So we see notice is a very important thing. And that's why for communities, if you come to us, kitu ya kwanza tunaulizanga, mmesikia wapi, si ndio? Mmesikia wapi is just not for the sake of mmesikia wapi. Mmejua aje. It's for us to know, was there a notice? Is the notice, so that we see from what angle are we advocating. If it was lawful, then we try and see how we can advocate for the community to be treated humanely. If it was, I mean in all cases, but if we see that it's unlawful, we also try and see what other strategies we can use. I think we seem to be coming to an end, to the end of this podcast, but just like some sort of a summary. I don't know how we will do this, but let's play some sort of scenario, or just exhibit what we have been doing. Communities come to us, they come to the office, we sit with them, they tell us they have a threat of an eviction, and this threat is oral. So what would you advise that community to do? Just step by step, to the point where, I don't know to what point, but step by step. I don't know if Jeff, you want to take that, or Tobias?
Okay,
Allow me do it together.
Yes, allow me to start, then Tobias maybe can come in. First of all, I said for a community to respond to an eviction, first of all, as Pamoja Trust, and even it will be apparent even for anyone who is trying to respond to an eviction, first of all, to establish who is the source of this message or even this notice. And so the community comes in and they tell us we've been informed of a planned eviction, or there's a proposed eviction. So we ask them who brought this message. And if they know, we probe further and ask them, is there written notice? If there's no, if they say yes, there's a written notice, we interrogate the notice for us to help them even develop an engagement strategy. And the first engagement strategy is, first of all, they need to go back and organize themselves so that they are speaking one voice. Because what we've realized and even experienced is communities, when they come to us, they have their personal, some of them have their personal interest. So sometimes if we do not, if they are not moving as they are not speaking in one voice, sometimes you may realize you are pursuing individual interests. Secondly, is that once we've established the source of this notice, is now we design a strategy for responding to that. And the appropriate strategy, there's no one universal strategy for approaching this some of these notices. So it depends with the organization or the institution, and again it depends with the magnitude of the eviction. Sometimes we, depending on the magnitude, at times we either result into a negotiation or we move to court just to, for purposes of ensuring that the process that we are undertaking is for buying in of time.
Okay.
Again, once we've the community has established who is the source and probably they have gone and engaged, that is when now we advise them now that we need to have information, and the information is in form of it's a general information. First of all, they need to know the impact, and the impact will be dependent on the data that they are going to generate. They need to know the population, the affected persons, so that even as they negotiate, they even let the other party know the weight of the impact. And after knowing the impact, with once now they've agreed on the data collection, at least you can see some ownership even in terms of these processes. Otherwise, you'd be seen as an organization. Maybe the community is doing it for purposes of maybe the organization is supporting them. Yes, and that is when now we allow the community to collect their own data, and then now once the finding now will inform either the magnitude and even the strategy for engagement. I'll allow my colleague to...
I think my colleague has said almost everything.
She's hit the nail on the head.
Kabisa. Maybe what you can add is that in this entire process, it's very important to ensure that the community needs is at heart of the process, and to ensure that whatever decision that the community decide to follow, they decide in a community meeting. So that the community leaders doesn't seem to be making decision on behalf of the communities themselves. Yeah, so I think that is important. In the all engagements in this process, the community leaders should be going back and taking the information back to their community members on what they have found out and the steps that they are taking, so that it becomes a transparent process that can be easily understood by all community members, including even the vulnerable.
Yeah, I agree. That's why most times we have a slogan that says umoja ni nguvu. If communities, if you don't work together, then I think there are high chances that whatever advocacy you're doing might not really go through. But also, as a legal or a legally trained person, I think sometimes when the communities come to us, there's a clear written notice with all the information. We can see that this eviction, high chances, 100% is going to be a legal eviction. What we do is sometimes to buy time, as Chef had said earlier, is to get a court injunction. And this is, we do not really support to 100% court processes, but we also know that it's an advocacy avenue that sometimes can work when depending on the issue. And so sometimes when there's a written notice, everything is clear, the avenue is an injunction to stop the process and see if the communities are well organized. I think that's it, guys. I think on the matter of eviction, I think that's what we can share with you today. There are other matters, like as a planner, and we've been talking about special planning. How can communities use special planning as an advocacy to argue out that they do not necessarily need to be evicted, but the development can coexist with the communities? And I think that's something that we will be able to also talk about. So if you have any questions in regards to what we have discussed today, or something that your community is struggling with, I think you can put it in the comment section. We'll surely address it. And also we welcome feedback on how we can also address and better these discussions that we have here as a podcast. So I'm tempted to give last word, but I think we are good. So until next time, bye.
Bye.
Thank you.